school bus with the flashing lights on this straight lane road. Regarding a cap, Your Honor is correct, the facts using the evidence. I don't think a maximum of a 5-year sentence is appropriate in this case. The legislature didn't think so, and Addy's family didn't think so either. That's why we made our initial offer to try and spare them having to listen to this. I think a minimum of 10 is fair, considering the kids on that school bus, the bus driver who had to watch this little child, her little sisters in the car, her older sisters, the rest of her family and friends who are represented here in court. I'm sure there are many more who couldn't make it today that love this child and now who have to live their lives without her. And so for her mom, her family, her friends, for all of them, I think a minimum of a 10-year sentence is the least that this defendant's actions deserve.
All right, you guys come back up to the podium and Mr. Addy,
Come on up, Kaylee.
Mr. Addy, anything else from you?
Oh, yes, Your Honor. May it please the court. Kaylee Andre has been accused today of some things that she plainly didn't do. Kaylee Andre did not skip her bond hearing. The practice of the courts here is that the defendants are kept in the holding area if a bond can be agreed to. That's what happened in this case. She didn't flee from her hearing. She didn't skip it. Kaylee Andre has wanted nothing more than to apologize for her criminal misconduct for the past 15 months. But she has been under bond conditions which require her to avoid any contact with the victim's family. Kaylee Andre has scrupulously followed her bond conditions. At the time of this tragedy, Kaylee Andre was a 25-year-old woman who respected authority and did as she was told. She was told not to drive drunk, and she did not drive drunk. She was told not to race, and she didn't race. In fact, there's a picture of her car brought to a complete stop, probably 60 or 65 feet after the point of impact. That is not a person racing. That is a person who understood that if you are in an accident, you are required to stop promptly. That is a person who followed the rules. Nothing that we can do here is going to bring Adeline back to life. That is what everyone here wants. That is the precious hope that justice cannot deliver. And that is the tragedy. Kaylee Andre's conduct was criminally stupid. Most crimes require an intent to do the act, an intent to kill the person, an intent to break into a house, an intent to do drugs, an intent to drive after you drank alcohol. In this case, the only criminal intent which exists is the intent to drive a car. That is the only intentionality that has been proven. Now, on top of this, there is negligence. There is recklessness. Absolutely. We do not dispute that. We do not deflect from that. We embrace the truth. But there was no intention here to hurt anyone at all. And that brings us to the crux of this case. As her friend testified, Kaylee was anxious. She was depressed. She was late for work. She was in a rush. This court cannot deter anxiety. This court cannot deter depression. This court cannot deter criminal stupidity. This court can only deter actions that are intentionally performed. And the only criminal intent in this case was the intent to drive a car to work on a cold, dark morning. Thank you, Your Honor.
Stay right here, Chloe. Ms. Andre, finally, you understand the charges coming against you. You understand your rights, that you voluntarily waive those rights and pled guilty to these charges. Therefore, the pleas are accepted and exhibits A and B are to be made part of the record. As to count 1, the homicide by vehicle in the first 3, I'll send you to 15 years. You'll serve the first 8 at the Department of Corrections. Count 2 will merge with count 1. As a special condition of the probation, once you're released, you will complete a single victim impact panel. And you will also, within 120 days of your release from incarceration, attend a risk reduction class. I am serving you with notice that your privilege to drive in the state of Georgia is going to be suspended. And before you're able to legally operate a motor vehicle on the highways or roadways of the state, it is required that you check in with the Department of Fire Services. You'll give this to Mr. Addy. You'll also be subject to a Fourth Amendment waiver as well as a specimen admissibility clause. As a special condition of the probation, you will not violate the criminal laws of this state, and your probation will not go non-reported while you have any conditions outstanding. Mr. Abbott, will you help Ms. Andre sign the driving suspension form?
I will, Judge, if I can find the appropriate place. I think it would be here.
She's supposed to sign.
The forms have been executed, Your Honor.
Ms. Andre, I'll also advise you to review these corpus rights because these are felony cases. You'll have 4 years from today's date to challenge the constitutionality of these proceedings pursuant to the habeas corpus statutes of this state. Do you have any questions, ma'am? Mr. Abbott, do you have any questions?
No, Your Honor.
Ms. Forrester, do you have any questions?
No, Your Honor, although I do need to advise the court that she is eligible for her first offender penalty.
That was not a request that was made.
We request first offender treatment, Your
Did you have a conversation with Ms. Andre about the benefits and burdens of first offender?
I did, Judge, and I explained to her that if she got 15 years on probation, which I expected, there would not be any real downside to asking for it.
And is it your desire to ask for it now?
Yes.
Ms. Andre, you're notified of the following concerning the first offender sentence you're requesting. If you as a first offender probationer violate the terms of your probation, the court may enter into an adjudication of guilt and proceed to sentence you to the maximum sentence provided by law. And for you on this case, that's 15 years. Do you understand that, ma'am?
Yes, ma'am.
Additionally, I want you to understand that if an adjudication of guilt is entered, you may be sentenced to a sentence greater or more restrictive than that imposed today. If you violate the probation, you can get a maximum of 15 years. You understand that, ma'am? However, if you are so sentenced, you will receive credit for the time that you've served on probation against any new sentence. And if you successfully complete this sentence, you will not have been convicted of a crime in this case. Ms. Andre, have you ever been convicted of a felony in this state or any other?
No, ma'am.
And do you understand the conditions of first offenders? I'll explain them. And did you discuss the benefits and burdens with Mr. Addy? And do you still wish to be treated as a first offender? Okay? And so I will accept the plea pursuant to OCGA 42-8-60. Anything else, Ms. Forrester?
No, Your Honor.
Mr. Addy?
No, Judge.
All right, Ms. Andre, if you will have a seat for me, the deputies are going to take care of you and I will take care of the paperwork. Before we adjourn, I would like to say to all of you that this is a tragedy in every sense of the word. And I do want to say to the family that I think you guys have shown remarkable grace and kindness in this matter. You've shown remarkable grace and forgiveness for Ms. Andre, who is obviously someone who did not intend for this to happen, but this is just the nature of these types of charges. I say always that we as people, for all the things that we have done, all the things that we've accomplished in our lives on this planet, we have not been able to come up with a word that sufficiently captures the loss of a child. We have words for everything else. We have words that are redundant, that mean the same thing 3-4 times, but we are unable to come up with one single word that captures the loss of a child to a parent. And so I think the thing that captures what happens here today is the statement from Karen that today is not a measure of your child's worth, and then there's no sentence that I can impose that can give you guys any measure of comfort. But I hope that at least by bringing it to a conclusion that you are able to at least move on from this part and go back to doing the real work of mourning the loss of this child. So thank you for coming in this morning and telling us about this amazing human that you guys had the pleasure of knowing for 8 years. And I hope that you have some measure of peace from the conclusion of this exercise. Let's take a 10-minute break while we resolve the other, come back and resolve the other issues.